partner of Fiffik Law Group with offices in Pittsburgh and suburban Philadelphia. Mike and his team have been supporters of Hope Grows, and their work to keep family caregiver out of harm's way has been really inspiring, and we really appreciate him. Some of you might have met him in Celebrating You last year. He was really great. Mike received his law degree from the University of Pittsburgh in 1992 with his undergraduate degree from Penn State University. He was selected as Pennsylvania's super lawyer. His cape is in the back for 2011 through 2024 in areas of business, corporate, real estate. He's an active member of the Pennsylvania and Allegheny County Bar Associations. He spent 12 years in the various roles of the board of directors for Concordia Lutheran Ministries, a large continuing care retirement community in Western Pennsylvania. He serves as chairman of the Ohio Western Pennsylvania Member Network Board of Directors, participates as a pro bono attorney for neighborhood legal services, representing clients with petitions for protection from abuse, and is on the Neighborhood Legal Services Reduced Fee Panel of attorneys handling domestic and bankruptcy cases, and is a volunteer attorney for legal resources for women at the YWCA of Pittsburgh. Without further ado, Mike, you can take it away.
Okay, well, thank you for that kind introduction, and thank you for having me today. I really appreciate being here to talk to all of you about that. You've got sort of the formal introduction to me as a professional, but I thought maybe I'd like to tell you a little bit about who this guy really is. So a little bit of personal information about me. I was born in Germany, not by choice, but my father was listening to the bad guys over there while he was in the service. I've jumped out of an airplane in the past. That was my mother's idea of a great Father's Day gift for my dad one year. So she thought she might kill two birds with one stone that day, but the chute's opened. Thank God the chute's opened. It was great. Married a pastor's kid when I moved to Pittsburgh, and still married to her. I have three lovely daughters, and have been an attorney here since 1992, practicing in Pittsburgh the entire time. And in 2020, due to a succession plan, I took over the law firm and changed its name here in 2020 and moved to our current offices here in Foster Plaza. I have about 45 employees here, and we practice in lots of different areas of law, but we do a lot of estate planning and elder law work for people all over Pennsylvania. We typically do about 1,200 engagements of wills, powers of attorney, healthcare directives, things of that nature for folks all over the Commonwealth of Pennsylvania. So that's really what I'm going to talk to you about, and have a little bit of a twist on it as it relates to caregiving. So let's talk a little bit about what we're going to talk about today. Here's our agenda. Talk about estate planning a little bit, because that's important for you, and it's also important for care recipients as well. We're going to cover topics related to caregiver compensation. Not a dirty word. We want to talk about that. We'll talk a little bit about long-term care planning. You know, that's kind of a super complicated topic, and it's gotten more complicated anymore these days. But we'll try to cover that, at least the high points, things that you might need to know, identify some issues, and all along the way, there are going to be opportunities for you to ask questions and for me to try to answer your questions. So be thinking about them along the way, and we'll stop after every one of these little sections to take a look at some questions. So by all means, we'd love this to be a two-way dialogue with all of you. So let's jump right in and talk about estate planning, which I often say is misunderstood and underappreciated. So here are 5 reasons why you should think about or prioritize your estate planning. And so many people either have never done it at all, or they're not really thinking about it like the way they should. So number 1, you never know when you're going to lose control or have access to your assets or to the things that are really important to you. And oftentimes that happens when you least expect it. So it's a good idea to get a grip on that stuff and get this done now while you can. A lot of folks don't engage in estate planning because they think that they know the law, right? I may think that I know how to fix my car or to do some type of project around my house. And when I get involved in that, I usually make mistakes because I thought that I knew, but I don't. And really the same holds true for estate planning and passing your assets on to your family. You think you know, but you probably don't know. And we can talk about some myths along the way about estate planning. Your health might fail. It's never expected, often not expected, but it's too late oftentimes to do this type of planning after your health has failed, or you just don't have the capability of really digging into it in the way that you would otherwise whenever you're healthy. You really want to. Sometimes we fail to plan when you can. Just another similar concept. We want to get this done. Sometimes even though you're capable of planning, it's a little too late. You might have fewer options available to you than if you started earlier. You have a lot more options to you. Time really creates more options to do more advanced planning whenever you take the opportunity to do it. And then finally, if you don't want to do it for yourself, do it for your family. Because as Aretha Franklin's family found out, because she had she wrote what she wanted done on pieces of notebook paper, some of which were stuffed into her couch. If you don't get these things done, the legacy that you may leave to your family is one of chaos, of stress, of anxiety, right? I've got a blog on my website, fiffiklaw.com. What we leave behind is really what the blog is called, and they're real life stories about folks who did not do their estate planning and what type of a legacy they left for their family. And they're all stories that I am sure you would not want to be yours. Now, if you don't have your estate planning put together, maybe I can make you feel a little bit better by telling you that the government has a will for you. Now, that shouldn't make you feel very good because who's going to trust the government to take care of their family? That's a little bit crazy. Nobody trusts the government, and they don't know anything about your family. That will that the government has for you is called the law of intestate succession. And it makes presumptions about what you would want to have done with your money and to whom that it would go when you waive your right. You literally waive your right to take care of your family. You waive your right to direct where all of those hard earned savings that you've worked so hard for all your life, it directs where those go. It just makes assumptions about all of that. So you're leaving it up to a lot of guesswork whenever you rely on the government's will for your estate planning. So to really put a point to this, let's talk about some real life situations and what happens when you don't have your estate planning put together. And I guarantee you that one of these situations will either be yours or certainly somebody that is very close to you. This will be their situation. So blended families, something that is not at all unusual these days. These are children, folks coming together that have children from a prior marriage or a prior relationship. These blended families may be in a marriage or they may just be cohabitating, living together, and everybody's under one roof kind of a thing. The government's will, at least in Pennsylvania, and there's a law of intestate succession in every state, so your state might be a little bit different. But the government's will is basically going to split your estate between your surviving spouse and your children from a prior marriage. And that's really not what most people want to have done. They typically want to have their estate fully available to their surviving spouse, and only then do they want their estate to be divided amongst their children. So the government's will doesn't do what most people want. It sort of splits the baby kind of a thing. That can be a real problem if the primary asset is the home where everybody lives and it's only in your name. Now you may have a situation where your surviving spouse is forced to sell the house in order to satisfy a division of your estate between him or her and your children to a prior marriage and your children to that person as well. Very, very tough situation. You also give up the opportunity to name a guardian for the assets to manage the money that you leave for your kids if they're under age 18, or maybe you want to have them managed even if they're over the age 18 and defer their enjoyment of that money until an age whenever they are maybe a little bit more mature. But you give up the ability to do that whenever you don't get your estate plan together. So, second real life situation: unmarried couples. Um, this is a tough situation. The survivor gets nothing, right? There's no presumption under the law that that your boo, whoever it is that you've been maybe even living with for a number of years, is going to get anything out of your estate. There's no common law marriage recognized in Pennsylvania anymore. And it doesn't matter how long you've been living together. And that's really the case in most states. There's no common law marriage. So if you think that if you've been living together for 7 years, you're common law married and you're going to inherit, you're wrong. It's not going to happen. This happened to a good friend of mine um, who was engaged to be married to someone. I knew both of them, and he literally dropped dead after mowing her lawn one afternoon, and she ended up inheriting nothing from him. They were engaged to be married. They're going to be married in a couple of months, and she got nothing. That's absolutely not what Paul would have wanted, but that's really what happened at the end of the day. So, not something that most people would want to have. It's especially a problem if the two of you have been living in your house and it just has your name on it. Again, your significant other could get the boot out of the house because it's got to be sold to be divided amongst your family or your kids. Stepchildren, also not uncommon at all in this day and age. They are not treated as your family. The government's will does not treat your stepchildren as your own children for purposes of dividing your estate. And that can be particularly difficult for folks who have stepchildren who they've known and loved for many, many years. It's not unusual for whenever I'm doing estate planning for folks that they tell me these are my stepchildren, but I want to treat them all the same, basically all the same. But they're going to get nothing. So that can be a little bit of a harsh reality. Single parents. Um, if I often tell folks whenever I do like estate planning webinars, this is really the one thing that I really want them to remember, because single parents have really, there's very little that is going to protect their kids. Who's going to manage your money if you pass away, especially if your kids are under the age of 18? Who's going to manage their money, the money that you're leaving to them? If you're divorced, would you want the money that you've earned entrusted to your ex-spouse to manage for your kids? In most situations, you wouldn't want that kind of a thing to happen. Who's going to care for your minor kids if their other biological parent is absent or just incapable, has problems, right? That is not unusual at all. We talk to single parents all the time who have no idea where the other parent is, or maybe the other parent's got addiction problems or behavioral problems or mental problems. If every day that you leave your house as a single parent of minor kids without having some plan for them in the event of a catastrophe, is really just it's dangerous thing. So really want to encourage people to get that done. And then single, no kids. You might think, why do I need a will? Why do I need an estate plan, at all? Well, um, young people have assets, right? Especially these days, they're earning good money, and those assets need to be administered. Who's going to manage their assets of their estate? What happens to your digital assets? We have more and more of our lives and things that are important to us that have real value locked into various accounts that are online. If it has a username and a password in order to access it, then that is a digital asset and they have real value, like rewards points, like money locked up in your Venmo or Cash App, like your photographs, like all of the digital files that you have saved on your phone or in your email or whatever it is. There's lots of valuable information in there. Maybe you have crypto. That's not unusual for young people to be interested in now these days as well. It's really something that you have to be thinking about in this day and age, not just the garden variety bank accounts and real estate and your 401k or your IRA. We have to be thinking a little bit more broadly about what the assets are that we have to take care of. Um, Now, let's put a little bit of a caregiver spin on this. So let's say you're a caregiver and you've got all your estate planning documents done, but you're caring for somebody. It's just as important for you to be aware of whether they have their estate planning done as well. If you're serving as a caregiver, one of the most important things that you need to be asking yourself or answering is, what is your legal authority when it comes to things relating to the person for whom you are providing care? These are some documents that every care recipient should make sure are in place. You know, who has authority to provide financial assistance for the care recipient? Typically that's accomplished by a financial power of attorney, sometimes called a durable general power of attorney. But that can also be accomplished by, having a name on a bank account, although we don't often suggest that people make accounts joint just to give them check writing authority, but banks can give people check writing authority, or you can be given online access to pay bills. But that's very, very limited ability of authority. Sometimes you need a general authority over the person's assets as they relate to everything: car, house, bank accounts, beneficiary forms, talking to financial institutions, doing all of those things that need to be taken care of in life. And sometimes it's particularly important whenever somebody gets older or they have to deal with government benefits of one kind or another. Having authority and figuring that out is a really big thing. And then you also need to know who can make medical decisions for this person who is receiving care. Who has authority, who has access to medical records. That's typically accomplished by a healthcare power of attorney. Also, a very important document to make sure that your care recipient has in place. Sometimes it's called a living will. Living wills typically involves end of life decisions. So really important to have that. I just talked to somebody this week. She was a caregiver for her ex-husband. And at the time that I talked with her, he was in hospice and really failing. And she didn't really have the ability to handle some things for him that she needed to. And so the purpose of her calling me was to see if we could get a power of attorney done, but he didn't have the requisite capacity in order to sign that document. So it really caused her a tremendous amount of anxiety because she wasn't able to help get some things done that he needed to get done in order to care for him, make sure his house was taken care of, make sure his bills were getting paid. It was a real scramble, really, at the end of life in the most difficult situation possible, because although she had been caring for him for 5 years, right, while he was able to sort of help her out, get those things done, it wasn't as urgent. And it only became urgent after she needed it. And he really wasn't there, right, in order to help her get that accomplished. It was just too late, at that point. And then unfortunately, some other family members stepped into the void and she kind of got left out a little bit, and that was very hurtful for her. So, that's not a good situation. It's really good to get those lines of authority set up, as quickly as you can, and as certainly as you can too. It's really important for care recipients to have their estate planning documents together. A will or a trust. Avoiding intestacy, avoiding the government's will, highly recommended. You don't want to have that happen for your care recipient. You know, we we oftentimes suggest a revocable living trust as a primary estate planning vehicle because it's sort of like a power of attorney on steroids. It's like a superpower of attorney because the assets are owned by the trust, and the trustee can control all of the assets in the trust. A power of attorney is giving somebody the ability to control assets that are titled in somebody else's name. So that's a little different, right? It's a little different. In a power of attorney is a very good thing to have, but you're sort of subject to giving that document to financial institutions and establishing your ability to control those assets. So if you have a care recipient that has a power of attorney or has given you power of attorney, it's very important to follow through to do the things necessary to make sure that that's going to work for you. So, for example, you should take that power of attorney to the bank where the care recipient has their accounts and make sure that the bank has it on file and they recognize your legal authority to transact on those accounts. The same would hold true to provide that to their investment advisors or anybody that they're working with. You have to give them copies of that power of attorney so that your authority over somebody else's assets is recognized legally, and you're, from a practical standpoint, you're able to do those things. A trust is a little different because you're the trustee and the assets are titled to the trust. And so there's less ambiguity over your legal authority to transact or control those assets. So it has a broader application, and it cuts out some of the friction that sometimes we see that caregivers encounter in trying to help somebody manage their affairs. We almost always do both of those just to make sure that there's clear lines of authority for caregivers. Beneficiary forms, also key documents for care recipients to have in place. Incomplete beneficiary forms or forms that are stale dated, things have changed, those can have significant negative consequences for in the event the care recipient passes away. It can expose the money in those accounts to government liens if they pass away. That can be a problem if they're left to their estate. And if those assets are left to somebody that has a government benefit, right, that has a resource eligibility component to it, it can cause them to be ineligible for benefits. So, if you leave, I have a brother and a sister who I've been helping. She's got the money, he's the caregiver, and he doesn't really have any assets, and he's already eligible for medical assistance. If she passes away, she wants to make sure that he receives the benefit of her estate. But if she just left it to him, put his name on a beneficiary form and passed away, now he's inherited that money. He's all of a sudden no longer eligible for the government benefits that he's been receiving. And he's just going to have to spend her money to pay for the things that the government benefits were already paying for him. That doesn't have to happen that way. That money can be left to him in a trust. It can benefit him. He can have access to it without disrupting his eligibility for whatever benefits that he is currently enjoying because of his status. So that would really be a waste of money, a waste of her assets, if that can be avoided. So let me just stop there and see if there are any questions that I can answer about those topics. Maybe Lisa has been scouting the chat and let me know if what's in there.
I have, so I actually had a question about how many times should you review your will? Like I can't even, now that I'm thinking about this, I'm not even sure who I have in my will at this point. So is there a timetable that you suggest?
I think looking at your will, certainly in life events, right? Kids are out of the house, or you get married or divorced, or there's a death in the family, or there's a health event of some kind. Those are all triggers that's something that you should be looking at. Otherwise, I think you probably look at it about every 3 years or so. And it's really important to understand how your will works in concert with the assets that you own, right? You can't look at one or the other and understand exactly what's going to happen in your life. You need to really look at them together, especially as it relates to retirement accounts of one kind or another and how that works. Your will only controls assets that are titled in your name. They don't control assets that are jointly titled, so it has somebody else's name on them, or that are controlled by a beneficiary form. They don't trump whatever's in the titling or the beneficiary forms. And a well-constructed estate plan has your will or your revocable trust and all of those accounts working in concert with one another to achieve whatever your ultimate estate plan is. So reviewing it periodically and also understanding how they work together is really important.
Great, thank you. Thank you for that. I know, I think Lisa Story wanted to share something. Amy, I don't know if you can unmute her, or Lisa, if you want to unmute yourself.
Yes, I'm unmuted and I will show my face as well. Hello, everyone. Hi, Mike. How are you?
Hello. Hi, Lisa.
Good to have you in our space
Thank you.
today,
Thank you.
sharing all of your wonderful expertise and knowledge. Hope Grows has, and I'll hold it up here in a minute, but it's an actual workbook that it says putting my house in order. It's a place to record for pre-arrangement and record of personal affairs. If anybody would like one of these books, you're more than welcome to it. Just let us know and we can get it out to you. But this is what it looks like. It's just a small little book. And it's exactly what it says. It's a workbook, and it's a place to record all of the things, just to begin to get all of your things in place, because as life moves on and kids grow and your assets change, like Mike has been talking about, it could be a really great place to have all of that recorded in one spot. And then and then it makes your estate planning that much easier because everything's in one place. So you're more than welcome to one of these.
That's a great word, Lisa, and especially as it relates to your digital assets, right? We have to be thinking about not just, normally estate planning was who gets what, when, and in what proportions, right? Those are that's the basics, right? But now that we have these digital assets, those questions don't really answer for the disposition of our digital assets. So for example, if you are on social media, if you love Facebook kind of a thing, you have to be thinking about, what do I want to have happen to my Facebook account after I'm gone? Do I want somebody to have access to my email account? What about all of the things that I have on my phone, like my photos? What do I want to have done with those? Do I want to have people know something about them or not? I had a client who, this is a second marriage, right? And her husband passed away. He had a couple of children, one of whom was adopted, except that child didn't know that. Maybe he wanted that child to know about it, maybe not. There are sometimes family secrets or things that you want to keep private, that you might not want to have discovered after you pass away. And nothing nefarious, but so you have to be thinking about those things too. That's the modern world that we live in, and getting our affairs in order really is now having to encompass those types of questions, as well. My mother is early stages of dementia. I'm trying to help her out with things too. And I have to say, one of the most frustrating things, and I bet you've been there, right? Mom has access to her bank account, but she can't tell me her username or her password. And maybe she has it written down on like some scraps of paper that are floating around, and you're sort of, okay, maybe this one will work, kind of a thing. Do your family a favor and put all of that down somewhere. And that workbook probably would be a great place to put them along with other important things.
That's great. Thanks, Lisa. I think Rosemary, you had a question if you want to come off mute.
Thank you. Yes, I have a couple questions if you don't mind.
Sure.
I wanted to know, Michael, a couple things. You had mentioned a few minutes ago when you gave the case scenario of the individual who it was a little bit too late for that all that estate planning to have taken place because the care receiver wasn't mentally able. You didn't have enough time to make that transfer to power of attorney. What in a situation like that, is it just too late? Is it too late to salvage anything, or is there a huge process to allow some benefit change to be made?
You know, I'll say that if you have more time, there's, you could have a guardianship type of a process, but that's a court process that is really going to require a lot of time to go through. There are some expedited ways that you can do that, but none of them are very fast. In that particular situation, because he was really at the end of life, you're kind of just stuck. There really isn't a lot to do. The only advice that I could really give to that person in particular, with his siblings coming in, right? I said, if you want to continue to be involved, my encouragement to you is to find a way to understand what the family needs and try to facilitate that, so that you're in the conversation as opposed to being viewed as an opposing force where they're just going to freeze you out. Now that's no legal issues there, right? It's more just sort of family type stuff, family dynamics and social dynamics involved there. It's a tough situation at that stage.
Thank you. And one other question, you mentioned revocable versus irrevocable. Is there a quick explanation to explain the difference?
Sure. We talk about, usually revocable versus irrevocable comes up in connection to using a trust of some kind as part of your estate plan. And think of a trust as an account, kind of. Just think of it that way, right? A revocable trust, or assets that are in a revocable trust, you have control over those assets the same way that you could control them without a trust. So there's no difference between the two. The trust is really it's just a way of providing very detailed instructions on how you want to have those assets managed after you're no longer able to do it because of disability, or after you pass away. That's what a revocable trust is. And an irrevocable trust is used for a variety of purposes, either to reduce death taxes, or to render you or protect assets in the event you're applying for long-term care medical assistance. But irrevocable means once you've set it up, you can't undo it. It's a gift that you can't take back. That doesn't mean that you lose complete control of the assets in all of those types of trusts. Sometimes you do, but there's going to be certain aspects to that trust that you can't undo or that you can't change. So hopefully that's a very, very high level explanation of that. So
thank you. Appreciate
sure.
it.
And there was a question in the chat, and then someone has a question, and then we'll need to move on because this is all good conversation. We have a lot to cover.
Yep.
The question was, can we instruct social sites to delete and cancel my account if it hadn't been open in 30 days?
Well, I think each social site's going to have their own rules. So I think you'd have to refer to the terms and conditions of each social site. Each social site has a set of rules about what happens after you pass away. Sometimes they may delete them after there's been no use. You may have seen in the news that Google was getting rid of accounts that had been dormant for 3 years. But the problem is, every site's different. They all have different rules. You can go to my website. I have a digital assets page on my website, and you can find, at least at one time, what all the rules were about what happens for accounts associated with people who have passed away, but they change from time to time. So there are a lot of ways of dealing with that, but the idea is you have to sort of think a little bit about it, and have some type of an idea or plan. But I don't think you can preset it to delete it in 30 days if they don't know when you die. You know what I mean? That's the issue.
And that was great. Thanks, Mike. And then there was one person who is on an iPad that had a question.
Yes, that would be me. My name's Terry.
Hi, Terry.
Hi there. My son, he's 31 years old, and in December he was diagnosed with Huntington's disease.
Sorry.
Yes, and I've suspected he's had it for a while now, but he hadn't gone through the testing. So he's lost his job. So he is symptomatic. and he is still living with his roommates, but I am supplementing paying for his rent. I do have him on unemployment and medical assistance right now. At some point here in the near future, I'm going to need to get him on disability. So I'm going to be starting to work on that. But his bank account, I am joint on that bank account. And you said I need to be taken off of that bank account as joint. My concern, I've talked to the bank about removing myself, but I keep an eye on his bank account to make sure he's not overdrafting, and I transfer money in and it's considered a loan so that I'm not financially responsible for him, because I don't want to be financially responsible in this situation. How can I still, like, if I'm removed as joint on his account, then I don't have access to go in and change a link to it right now from my account. So I can easily go online and just transfer money. If I'm not on there anymore, then the bank's saying I'll have to call them and transfer money, which, doesn't work after hours and weekends.
Yeah. I mean, if there's not a lot of money in that account and you want to be joint just for managing it, I don't think that's a big problem. If it's his, I wouldn't have him joint on any of your accounts. That's for sure. So
Yeah,
I wouldn't worry too much about that.
Okay, because he's like, yeah, he basically has no money.
Yeah.
He's broke.
You have to be thinking about your own estate planning to make sure that, if you are going to leave him money out of your estate, that it's protected so that it doesn't render him ineligible for benefits as he's going on in life. So that'll be
Yes.
an important planning point for you.
Yes,
And to
because
make sure
I
that he has
do.
his stuff in place too, right? He needs to have a power of attorney and a healthcare directive and all of that kind of stuff, so that somebody can make decisions for him, if his condition, impairs his ability to do those things for himself.
Yeah, which it will. It will probably within the next. I think he's probably got about 2 good years left.
Yeah, it's really important to do that. I've had occasion to have to file guardianship petitions on behalf of parents for their adult kids, and it's traumatic, especially if the kids have enough awareness and they don't like it. So it would be much better if he were to put all of those authority documents in place now, so that you wouldn't have to resort to a court process like that, which is just expensive. You don't have to do that.
Okay. And then like leaving him as beneficiary is okay if I do basically a kind of a trust.
Yeah. Yeah.
Okay.
You want to have his money left into a trust of some kind that will, um, allow for him to benefit from that money, but not be available to him in such a way that it would make him ineligible for benefits. So they often call that, in very generic term, a special needs trust or a supplemental needs trust, of some kind. But yeah, that's what you'll need to have, incorporated into your estate plan as it relates to your son.
Okay. And then I'd have to set someone up in case something happens to me that they can manage that for him.
Yes. Yeah,
Okay.
absolutely.
Thank you.
Sure.
Thanks. Thank you, Terry. Okay, I think we'll need to move on. And I just will say that this probably will go over. So if anyone does have to drop off because they have a hard stop at 1, we will have the recording there, but we will go probably until 1:15. So
Okay.
go ahead.
I can dial it up a notch here.
Okay, great. Thanks.
We'll get through it. So, very briefly, caregiver compensation. It's okay to be paid as a caregiver. There are a ton of caregivers in Pennsylvania, and they spend an enormous amount of time, like Lisa said, for her parents. They spend an enormous amount of time providing care. And, I've seen lots of different estimates of what the value of that care is, but it's enormous. Society is reaping a tremendous benefit from the work that caregivers are providing. There's even there are, in some states, they provide tax credits for caregivers in recognition of all of the financial sacrifices that caregivers endure as a result of caring for their loved ones. So, but it's also okay. It's okay for you to be paid, right? Caregivers experience reduced finances when providing care in the way of, maybe they retire early, they have lower Social Security, they have lower retirement because they didn't work as long and build up as many savings. So it can be a real financial burden. if you're going to get paid as a caregiver, I would highly encourage you to have a written caregiver agreement put in place before you start receiving payment for the services that you're providing. And this can happen with a parent. Don't, just because it's a parent, don't treat it as it's informal, right? Because if your care recipient ever needs to apply for any type of medical assistance benefit, they're going to look at asset transfers for the applicant that occurred in 5 years prior to their application. And if there is a record of payments being made to you as a caregiver that are done just informally, those will likely be treated as gifts and could cause a period of ineligibility for medical assistance, especially long-term care medical assistance, or even for home care. And you don't want to have that happen. So having a written caregiver agreement that's done properly can protect or make it less likely to have those types of problems, and protect Medicaid eligibility. You also, if you're going to be a caregiver, paid caregiver, and receiving Medicaid, and the care recipients receiving Medicaid benefits, you can't have a power of attorney for that person, either financial or medical, I believe. So that's something that we have to think a little bit about if that person is receiving government benefits, Medicaid benefits under one of those programs. There's going to be some restrictions on that, so we have to be aware of that too. A spouse cannot be a paid caregiver under any of the rules that I'm familiar with. There are Medicaid programs that are available to paid caregivers, and there are eligibility requirements for both the caregiver and the care recipient. You have to be 18 years old and a PA resident. You have to complete some training, and you're typically paid through a private home care agency. You don't get paid by the state. The state isn't in the business of paying caregivers. They do that through agencies. And, there's typically an hourly rate. This is for Medicaid programs where you're getting paid. As a private caregiver, the rate might change a little bit. That's going to have a little bit more flexibility to it. You can't pay yourself $100 an hour, but there's going to be an amount that will typically pass the smell test for medical assistance in order to not be deemed a gift on a transfer if you're getting private paid by the care recipient. And elder law practitioners can talk to you a little bit about that. The caregiver eligibility, spouse can't be eligible. The caregiver can't have the power of attorney for the care recipient. So the most common situation this happens is a child who is a caregiver for a parent, my neighbor, and all of her siblings do that for their mother currently under a waiver program. So that's what's happening for them. The care recipient eligibility, there of course has to be medical necessity. So there'd be a physician certification that's required. They have to meet financial eligibility requirements for Medicaid, and there are both income eligibility requirements. So their monthly income has to be under a certain amount in order to qualify. And there is an asset requirement, meaning they can't have assets that are worth more than, at a maximum, $8,000. So it's very low. We'll talk a little bit more about that. So here's some eligibility numbers. These change on an annual basis. They're also different from state to state. I think these are the 2024 numbers here in Pennsylvania, that the eligibility for the financial recipient, the care recipient, their gross income max is $2,829. Assets $8,000 max, and eligibility is typically determined by the county assistance office. So that's a very quick review of caregiver compensation, and I'm happy to answer any questions about that anybody has as well. If anybody has any questions, I don't know.
Michael, I do. There was a conversation that I had with someone at the Sewickley Y that said that there is a link on the PA government website that has an application for family caregiver compensation. Have you heard of anything like that?
Yeah, I'm not quite sure what they're referring to. There's certainly lots of information at the Department of Health on these programs. So I'm not quite sure what that's referring to offhand, no.
Okay, check that out. And also for everyone, Amy, our communications on the spot, she did put the link to the digital assets post that Mike has made. So
Oh, great.
it's in the chat. So if you want to copy it, you can do that.
Okay.
All right. Go ahead, Mike.
Long-term care planning. I actually did a more extensive webinar yesterday on long-term care planning, and that will hit my YouTube channel for Fiffik Law Group on YouTube. There are lots of videos on there about estate planning related things. So in the next couple of days, if you want more information about this topic, you can go to my YouTube channel and watch that webinar. It was about an hour long. It was pretty in depth on long-term care planning. So we're just going to cover a couple of highlights, right? So there are a variety of types of long-term care, meaning facility-based care. You know, if personal care and assisted living, those are essentially the same. We have nursing care, skilled nursing care, and hospice. And home care is also a type of long-term care as well. If you have somebody that are able to come in and take care of you at home. Planning, is critical. And for a lot of people, this is going to be a reality for them. 70% of our population over the age of 65 are projected by the federal government to spend some time in a care facility of some kind in the future. I've seen estimates that the average stay in long-term care is 4 and 5 years. Really depends on your level of health. I think that can really vary from time to time and when you enter into a facility. But, in my experience, that's not terribly unusual. Skilled nursing, I've seen averages of 2.2 years. I think it's probably a little less than that. But, here's the big problem, the cost of care. The average monthly private pay rate for skilled nursing, right, which is the most expensive, is about $11,000 a month. Very expensive. The average daily rate, 380 bucks. Annual cost, almost $140,000 for skilled nursing in Pennsylvania. So, when people think about asset protection planning and nursing home planning, I suspect that what they're really thinking about is, they're going to have to spend their life savings basically to stay in a nursing facility or skilled nursing facility. And it can really deplete your savings fast. It can be very scary if for a married couple, if one of them is in skilled nursing and the other is still living at home. Now you've got double expenses that you have to pay, and you can see your savings dwindling and worried about whether your spouse at home is going to have enough to support themselves. It can be very devastating financially from a cost perspective. It's important to understand how care is paid for as well. Most is private pay, right? Personal care, assisted living is private pay. If you want to have somebody come to the home to care for you, most of that is going to be private pay. There is some limited amount paid for by long-term care insurance and other payers like the VA. Medicare pays very little and only for skilled nursing by and large, or hospice. That can be paid. Medicare can pay for those. And then if you are financially eligible, Medicaid can be available to pay for skilled nursing or for some home care services as well. And because it's so expensive, the government, Medicaid is a federally funded but state administered program. The state is very keen on reducing the amount that they spend for Medicaid for our elderly. So this is a big problem, and it really requires you to be thinking about doing some planning in advance to avoid the devastating financial consequences of going into this with no plan whatsoever. It's tough to think about. So, as I said, medical assistance can be available to pay for skilled nursing. It does not pay for personal care. It does not pay for assisted living. It can be available for home care as well. We talked a little bit about that previously. But the idea of some nursing home planning is to structure or protect some of your assets in anticipation that you might need skilled nursing in the future, and to help you become eligible to have medical assistance, pay some of that, and to preserve some of your assets so that they're available to support your spouse that's at home, or to leave a legacy for your family. And there are income limits, meaning your income has to be below a certain amount, and asset limits. They're all the same figures as I gave you for home care benefits, right? Now, whenever you're looking at the assets that you own for purposes of eligibility for medical assistance, there are we categorize your assets into two different buckets, right? Ones that count for purposes of eligibility, and ones that don't count for purposes of eligibility. It's important to understand that. Assets that are disregarded or that don't count whenever you're applying for medical assistance include your home, up to an equity amount of, I think it's $713,000 this year. Most people, that's not a problem. One car doesn't count. Prepaid funeral plan doesn't count. Household goods, very, very small life insurance policy, cash value, 1,500 or less, and your spouse's retirement accounts. None of those are counted for purposes of getting you at that $8,000 or below, 2,400 in many instances, in order to qualify for long-term care medical assistance to pay for some of that skilled care. Now, some other key concepts to have in your mind relating to this, and this is a very, very high level, very brief overview of this subject, is that in a situation where there's a married couple and one has to go to skilled nursing, they have usually a sudden health event of some kind that renders them disabled such that it's just not possible for them to go home. Maybe somebody's had a stroke or a fall or broken hip or something like that, where they're just not going to be able to come home for one reason or another. You've got that expense, and then you got the other one living at home. They call the one living at home the community spouse, still living at home. If there's an application for medical assistance, you're allowed to protect or cordon off or segregate some of your assets, for the support of the spouse that's still at home and still be eligible for medical assistance. That amount changes every year as well. I believe it's up to about 150,000 in 2024. And so part of the planning that goes into helping people become eligible for medical assistance, but also protect their assets for other uses, is to maximize the community resource allowance available for that spouse at home. But that's out there. Whenever you are doing planning in anticipation of the possibility of needing nursing care and wanting to cause yourself to be eligible for medical assistance, so that picks up some of the tab, you have to understand that when you transfer assets, and then apply for medical assistance, they're going to look back 5 years to see what transfers that you made. They don't want you to give all of your assets away and then apply the next day and have the government start paying the tab. So they don't want you to impoverish yourself just to qualify for medical assistance. So that 5-year look back, right, is a significant factor in planning to protect your assets in anticipation of needing nursing care and having medical assistance to pick up some of the tab. And then we also another important concept about long-term care planning or asset protection planning is the fact that if you are in skilled nursing and medical assistance does pay for it, after you pass away, the state is going to have a lien on your probate estate. It's called Medicaid estate recovery. So they're going to want to get paid back out of your estate. Now that lien or that Medicaid estate recovery applies only to certain types of assets, and it doesn't apply to all assets. For example, assets in an account that are controlled by a beneficiary designation can escape that. So another point of doing some asset protection planning or long-term care planning is to recognize that Medicaid estate recovery potential out there and to title or structure your assets in such a way that they won't be subject to that lien. They won't get clawed back in order to pay the state back in the event that you receive long-term care medical assistance to pay for some of your expenses. So when we talk about nursing home planning or asset protection planning, we're talking about asset protection techniques to cordon those assets off so that you leave something to your family. There might be some gifting that you have to do to transfer assets from yourself to a trust or to someone else in order to shelter them and protect them. We maximize that community spouse resource allowance. We might do what's called a smart spend down. If somebody is about to go into a facility or they're in a facility, it's not too late to do this planning. Somebody may find themselves in a facility. The facility will do an assessment of your eligibility for medical assistance and tell you have too much in the way of assets. You're going to have to spend down to this amount and before you can become eligible. Well, there are lots of different ways of spending those excess assets down in order to become eligible. You don't just have to spend it at the facility. You can spend it on lots of different things that you can get some benefit out of and get yourself to an eligibility point pretty quickly rather than paying for several months at $11,000 plus a month before you become eligible. So it's not too late to do that type of planning when you're about to be or you're already in a facility, right? We can do something called a smart spend down. And we do a lot of work with trusts as well. So again, that's very high level. That requires a lot more conversation, but I'd be happy to answer any questions that I can about asset protection planning, long-term care planning.
Yeah, there was one. Rosemary had a question about the long-term care insurance, and does it only pay for skilled nursing level, or can it cover personal and assisted living costs?
It can. It depends on what type of product that you buy, but it can pay for any of those. Just depends on what you buy.
Great. Okay. And Lisa had a question up here too. Wait one second. She wanted to know if there was something you can help direct a caregiver to learning more about how to get paid, if there's a resource or if you had a blog post or something like that.
Yeah, I don't have a blog post currently. Let me see what I have, and maybe I'll be able to send that through you, Lisa, to the attendees of the session.
All right, that sounds wonderful. And really, I was grimacing as you were talking about this because I didn't know any of that, and that smart spend down would have been really helpful for me. So people get with it, or you'll be like me. Anyway, okay, so yeah, we're coming to the end here, so that's great. Go ahead.
Yeah, no, I was just going to say, I've got we do a weekly webinar about wills and trusts. My partner Kevin Frankel in my Philadelphia office does that. So if you want to know more about trusts, revocable trusts, irrevocable trusts, asset protection trusts, that webinar is a great one to do. You can talk to Kevin about that. It's every Wednesday at noon. Every Wednesday at noon, you can register on my website and he'll tell you everything that you want to know about that, or schedule a one-on-one with either Kevin or I or a member of my team about asset protection planning. And let's see. Here are some upcoming events for Hope Grows too. Lisa,
yeah, so we have, as part of the expert, Ask the Expert, we're planning, because of Women's History Month, to do a panel of women from all aspects of caregiving. So we're looking at March 29th, so be on the lookout for registration for that, because that should be a really good one. We're hoping to have it at the house here, at the Irish Respite House. And then our 10th annual Victorian Tea is happening Sunday, May 19th. We changed the venue because of the 10th year to go to the Omni William Penn downtown. And if you know their high teas, you know that they do a great job. So we're excited about that and hope that we can see you all there.
Let's see. That's it, right?
Well, there actually is another question.
Great.
So let
I'd
me.
be happy to answer more.
Okay, great. Elaine has a question for you. Elaine, if you want to come off mute.
Yeah, hi. I don't know if this is too big a question, but I wondered if you could comment about the annuities that are available if you're going to go into to try to become eligible for
Yeah.
assistance, and like what are the good parts and the bad parts?
Yeah. So what Elaine is referring to is a technique where somebody is about to be in a facility or in a facility and they have excess assets, right? They're not eligible. They have to do a spend down. One technique, I'd say generally, is converting an asset into an income stream, right? That's a technique to get you eligible for medical assistance. And one way of doing that is to purchase a special type of annuity. It's an immediate annuity. It's an irrevocable annuity. It's a lump sum payment annuity where you put the excess assets, you use those to purchase this annuity, and it just pays you an income. Now you no longer have a problem qualifying from an asset perspective. It could impact your eligibility from an income perspective. So that's a little bit of an assessment that has to be done. But that's the basic technique. That's what you're talking about. It isn't any annuity. They have to be meet specific requirements in order for that to be a technique. Sometimes what people will also do is maybe do like a private promissory note. I know in some states that's popular, where you give money maybe to a child and they give you back a promissory note where they have to start paying you an income on that promissory note. It's a similar concept, but you're taking excess assets, converting it to a stream of income in order to be eligible for medical assistance immediately.
So just as a follow-up, I'm curious, so just say, for example, you got one of those Medicaid eligible annuities, and then your spouse passes. Then what happens to that? What happens to the money that's in that annuity?
I think it's going to be subject to estate recovery. That'll ultimately be the beneficiary. Yeah. That's
So,
one of the
okay, so
bonus.
you don't get that money, but once you put that money in that annuity, you're only getting back as much as long as well, in my case would be your spouse is like still alive and.
That's right. Yeah, that's right. So, I mean, it can be a great tool if you've got, not a lot of excess assets, because the benefit that you get on a monthly basis is going to have a high value versus what you might lose there. So, you have to balance. You have to look at the situation to see whether it's the right tool to use in that particular situation.
Okay, thanks very
Right.
much.
Yeah, you might be able to spend that money on improvements to your home if you still have a home, or buy a new car, or buy a prepaid funeral plan. Those are all things that you can spend money on to spend yourself down to eligibility. But an annuity is another tool that can be used. Yes.
Okay, thanks.
Sure.
And one last question here was from Rosemary. Wisdom and ability to convert straight will to a trust. Is this advisable?
Convert a straight will to a trust. I mean, a will, I'm not sure what you're referring to, but a trust and a will and a revocable trust are just two different ways of accomplishing your estate plan, two different tools to use. Sometimes you have both at the same time. You wouldn't necessarily convert. I mean, if you had a will and you wanted to use a trust, then you'd probably still have a will, but you would change your will and say everything that I pass away with in my own name, if that happens, just gets paid to the trust. And then your trust is going to do all of the hard work. That'll be the workhorse for explaining what happens with your assets after you pass away. So I hope I answered that question if I'm understanding it correctly.
I thank you. Yeah, that was me asking that, Rosemary.
Okay.
And I just, yeah, I didn't know if it was advisable, if one is more powerful or is going to be more protective, or is it in lieu of each other?
Well, I would say a trust is going to do more for you than a will can. But a will is a perfectly appropriate estate planning tool to use for many, many people. A trust is going to have is that what the trust does that the will can't do, right? A will only is applicable after you pass away. So only your family benefits from the will. You don't. A trust, on the other hand, you can benefit from it because it is active and working while you're alive. So that if you become disabled for some reason, then you have a contingency plan in place for a successor trustee to come in and manage your affairs for you during your period of disability or unavailability, or whatever it is. So it's a tool that does it. It's like a utility knife that has a lot more things that you can fold out, right? It does a lot more things for you than a will does.
Okay. Thank you. That's a big
Sure.
help. Thank you.
Okay, well, I think we have concluded this first Ask the Expert. Thank you so much, Mike, for being our inaugural Ask the Expert. All of the information, I believe, was very beneficial to a lot of people. The questions were great. And we will share the recording as well to people who have some questions, and of course, refer people to you. So definitely want to thank you for your insights and your great advice. And I want to thank everyone else for joining us today.
Thanks, everybody. Thanks for having me. It was a pleasure. And I'm glad you asked some questions. I really appreciate those.
Yes, absolutely. Let's see here. Yeah, so there are lots of thank yous going around in the chat. So
Thank you.
okay, so I think we will wrap this up. Thanks, everybody, for coming, and have a great weekend.
Take care, everybody. Bye-bye.